Welcome to the Founding Partner Podcast. Join your host, Jonathan Hawkins, as we explore the fascinating stories of successful law firm founders. We'll uncover their beginnings, triumph over challenges, and practice growth. Whether you aspire to launch your own firm, have an entrepreneurial spirit, or are just curious about the legal business, you're in the right place. Let's dive in.
What are the 4 essential issues to address in any law firm partnership agreement? Hi, I'm Jonathan Hawkins, and you're listening to the Founding Partner Podcast. Today, I'm going to talk about the 4 things you need to make sure are covered in your law firm partnership agreement. If you don't cover these, you're setting yourself and your partnership up for heartache. At the end of this, I'll give you a bonus tip, so make sure you stick around. But before I dive in, first thing that you have to have is a written partnership agreement. I know some firms that operate on a handshake. Yes, it can work, but remember, it works until it doesn't. And when it doesn't work, it can be pretty bad. So, again, written agreement, but not just any written agreement, a well-written agreement. I can't tell you how many written agreements I've reviewed that, let's just say, weren't very good. So, here are the 4 essential elements to address in a law firm partnership agreement. Number 1, voting/decision making. Number 2, exit ramps. Number 3, partner compensation. And number 4, dissolution. All right, let's start at number 1, voting and decision making. So these are some of the questions that you need to answer as you are drafting your agreement. How will decisions be made? Who gets to vote? Is there an executive committee, managing partner? Do all the members vote? These are questions you need to think through. If there is an executive committee, who's on it? How does the executive committee vote? Do you reserve certain decisions for everybody to vote on? And what are those? Is it majority vote, supermajority vote, unanimous vote? If there's just 2 of you, what if there's a deadlock? As you can see, there's lots of different questions and lots of things you need to think through that I guarantee you most people going in are not thinking about. They're thinking, hey, we're all great friends here. We all have the same mission, the same vision. It's going to be easy. Well, now's the time in the beginning to make these decisions. So later on, if anything goes sideways, you have something to go back to about how decisions are made. All right, number 2, exit ramps. This is what I call them. So what do I mean by exit ramps? These are all the ways a partner might leave the firm. So death, disability, retirement, voluntary withdrawal. Maybe you have to expel somebody for cause, maybe without cause. Lots of different ways somebody might leave. So what happens in each of those scenarios? It may not be the same thing. Probably not. If somebody is expelled for cause, that means they did something bad. They should not be treated the same way if somebody retires. So you got to think through that. Is there any sort of buyout obligation when somebody leaves? Does that change, again, depending on why they leave? Is it a lump sum payment? Terms? Might there be any offsets for certain firm obligations? For example, if the firm has a 20-year lease, hopefully you don't have a 20-year lease, but a long-term lease, and somebody leaves, should they be responsible for some or all of that? Or maybe there's a line of credit that the firm has used over the years, and there's a balance when somebody leaves. Again, you got to think through these things on the front end, because otherwise, when somebody leaves, you'll be dealing with them then, and it may not be so easy. All right, let's move on to number 3, partner compensation. This is a biggie. This is where most people focus. I've seen many 1 or 2 page partnership agreements that all it talks about is compensation. I guess that's better than nothing, but frankly, it's way more than that. Everybody wants to get paid, and you don't want anybody to be guessing how they're going to get paid or have disagreements later. So you really need to address this. Real quick, if you haven't gotten a copy yet, please check out my book, The Law Firm Lifecycle. It's written for law firm owners and those who plan to be owners. In the book, I discuss various issues that come up as a law firm progresses through the stages of its growth, from just before starting a firm to when it comes to an end. The Law Firm Lifecycle is available on Amazon. Now back to the show. Now, a few weeks ago on this podcast, I dropped an episode where I talked about my current thinking and maybe philosophy on equity partner compensation. So if you haven't heard that one, I'd say go check that out. You might learn something there that you can apply as you're drafting your agreements. So go check that one out. All right, number 4, you got to address dissolution. Now, a lot of people come to me and they say we're dissolving the firm, but dissolution is really a technical term. It's not some people are leaving, some people are staying. It is the firm is shutting down. Everybody's leaving and the firm is shutting down. And so you need to figure out what happens in that scenario. And how do you make that decision? Is it unanimous vote? Is it majority vote? And if you do dissolve it, what happens? You've got active client matters. You've got old client files. You have potentially leases that have terms on them, unpaid debts. You have all sorts of things you got to sort through. And maybe you have assets, although many firms, law firms, don't really have that many assets. I mean, you got furniture and maybe some computers. And from my experience on the furniture, you pretty much have to pay somebody to come get it. So I'm not even sure that's really an asset. But either way, these are things you need to address. I mean, certainly there's going to be AR, cash, hopefully, and you got to pay off debts and then split it up. So you got to deal with that. So just to be clear, these are the 4, I think, biggies. They're not the only things. There are lots of other things that need to be covered, but those are the 4 big ones. I've read a lot of law firm partnership agreements in my career. Some of them are pretty good. Some of them are really good. But I would say on the whole, most of them are lacking. They may be borrowed from some other type of business and they just change the names and put in the law firm names without really giving any thought to the scenarios of what might happen down the road. And law firms have peculiar scenarios that other businesses do not have. So you've got to make sure that whatever you're building is built for that. And remember, we have all the ethics rules and all the ethics opinions that sort of run through all of this. There are certain things we cannot do as lawyers. And I've seen plenty of agreements that put things in there that are violations. And sometimes they're not in the rules or the opinions. You got to go to case law to find this stuff. So anyway, if you're out there about to form a partnership, or maybe you have a partnership and you have questions about it, please reach out. Happy to discuss it. All right. I promised a bonus tip. And this is it. And I can't remember if I covered this in the partner compensation episode, but when I draft partnership agreements, I really like to have the equity partner compensation scheme or agreement in its own separate agreement, sort of a side agreement that's referenced in the partnership agreement, but it's got its own agreement. And I have a reason for this. The reason is I have found that partner compensation plans, schemes, whatever you want to call it, need to be changed periodically as facts on the ground change. If it's buried in the actual partnership agreement and you need to change it, then the whole thing gets cracked open, and then people start wanting to renegotiate, change this, change that. And you never know what's in the back of their mind. Why do they want to change this provision? Maybe they have something that they're planning to do. But if it's just the compensation by itself, I have found that's just a little bit easier to open up and change and then close it back down. And then you keep the partnership agreement as originally drafted in place. So anyway, that is the recommendation there. All right, that's all I've got for today. One last thing before I let you go. If you get any value from this podcast today or any other episodes, please take 5 seconds and leave a 5-star review. It doesn't take long. Couple buttons and we're there. I really appreciate your support and would appreciate a review. Thank you.
Thanks for listening to this episode of the Founding Partner Podcast. Be sure to subscribe on Apple Podcasts, Spotify, or wherever you get your podcasts to stay up to date on the latest episodes. You can also connect with Jonathan on LinkedIn and check out the show notes with links to resources mentioned throughout our discussion by visiting www.lawfirmgc.com. We'll see you next time for more origin stories and insights from successful law firm founders.